So your tenant owes you $2,000. You served them a 3-day notice and you did everything correct. And then 2 days later, $500 just shows up in your bank account from a payment app you completely forgot was connected. You didn't agree to it, and you never even saw it land in your bank account. But that one little transfer can kill the notice you're standing on. I'm Chrissy Wade, broker and owner of WELLSPRING Property Management. 10 years, hundreds of units across the state of California from Ridgecrest to Stockton, and I've watched this exact thing wreck a perfectly good eviction. So by the end of this video, you're going to know exactly what to do the day that money lands. There are 2 safe moves, but there's also a third one that most landlords make, which is the expensive one. So let's start with the thing everything else hangs on. The 3-day notice isn't a request. It's a demand for one specific number, and that number has to be exactly right. Not close, not rounded, not about what the tenant owes, exact. And I want you to feel how tight that is because it's tighter than you think. There's a California case where the landlord was off by $5.96 on a notice demanding over $1,000. $5.96, the notice was defective. So please, please, please don't build your whole plan around a judge waking up in a generous mood that morning. A couple more things people get wrong right on the face of the notice. And these ones are so easy to fix. Rent only, not the late fee, not the utility reimbursement, not the pet fee. And I know you're owed that money, but it still doesn't go on this notice. And the rent you're demanding can't reach back more than 12 months. Okay, so the $500 lands. Now what just happened? 2 things, and they're separate problems. The first one, just math. Your notice demands $2,000, but nobody owes $2,000 anymore. So now that notice is standing on a number that isn't true. The second one is the one with teeth, and it's called waiver. California has a standard jury instruction for this, and I want you to hear how short the list is. In residential cases, the tenant's side has to prove one thing, just one, that you accepted rent after the 3-day period ran out. That's the whole defense. There's no second part about whether you meant to, nothing about whether you sent a letter explaining that you weren't waiving anything. But I know some of you have heard that you can take a partial payment, send written notice, and that doesn't waive your right. You can just keep going. That is a real statute. It's also for commercial properties only. The statute defines commercial real property as everything in the state except dwelling units, mobile homes, and recreational vehicles. Residential is completely carved out by name. So if you own a house, a duplex, an apartment building, that protection isn't yours. Your very well-written warning letter doesn't create a defense the legislature never gave you. And listen, I don't love it either, but it's totally the law, so we gotta follow it. So the residential rule is the plain one. You accept rent after serving the notice. You waived that notice. You serve a new one for the exact amount still unpaid. Now here's what makes this trap different from every other notice mistake. And honestly, this is the part that bugs me the most. Most notice mistakes are things that you did. You typed the wrong number, you served it the wrong way. There's a moment you can point at. Now this one happens while you're asleep. Zelle, Venmo, the tenant portal, the autopay they set up 11 months ago and haven't thought about since. The money moves, it clears, and it sits in your account, and not one human being in your office made a decision about anything. And the court doesn't care that you weren't watching. It's looking at whether the money came in and stayed. Oh yeah, and there's a version of this that's completely worse than a dead notice. Stay with me, I'm gonna get there. All right, good news, and this is really good news. Money touching your account isn't automatically acceptance. There's a California case where the landlord kept his position by returning the rent, those checks that they paid, uncashed. Now those 2 words matter, returned and uncashed. A payment you deposited and then thought about for 2 weeks, now that's not a return. A payment that you refunded the same day in writing with a date on it, completely different set of facts. Which brings me to what you actually do. But before I give you that, sit with something for a second. Every restart in this process is another month of rent not showing up, plus a filing fee you already paid, plus your own hours. And I know nobody counts their own hours in this. That's exactly why I built our self-managing cost calculator. It's free and it puts real numbers on what self-managing may actually be costing you, the mistakes included. It's at wellspringpm.com/calculator, and the link is going to be below in the description. All right, 2 doors, and the one you pick the same day the money lands. Door 1, refuse it, send it back promptly, uncashed or fully refunded with a short, dated, written statement that you're declining the payment because a notice has to have been served. Screenshot it, keep the timestamp, and then just keep going on your original notice because it's still clean. You never accepted anything. Door 2, take it on purpose and then serve a brand new 3-day notice that same day for that exact new balance. So $2,000 minus $500, your new notice demands $1,500. That notice is good. Your clock restarts, and yes, you do lose those days. I know it stings, but you walk into that hearing with a notice that survives. Now, here's the third thing, which is what most landlords actually do. Nothing. The money just sits there, nobody sends it back, nobody serves a new notice, and then months later, you're standing in front of a judge holding a notice that demands $2,000, and the tenant's attorney slides a little bank record across the table showing you took $500 of it. That's the mistake. Not taking the money, not refusing, not deciding. And that worst version I promised you, here it is. If that money reads as rent for a period going forward, so next month instead of back rent, now you're not just looking at a broken notice. California law treats as evidence the tenancy has continued. So you may not have handed them a defense. You may have handed them a whole new renewed tenancy. So let's put some real numbers on this. These are illustrative, of course. Rent's $2,000. Tenant sends in $500. It sits. You file anyway. At the hearing, the notice fails. You're not appealing that. You're starting over. A new notice, new 3 days, new filing fee, and those run a few $100s depending on the county you live in. Then add back in the calendar days. 4 to 8 weeks is common. On a $2,000 unit, that's roughly $2,000 to $4,000 in rent. That's never going to show up on top of the fees and hours you have already burned. So that $500 payment, did it cost you only $500? All right, so let's close the loops. 2 safe moves: return it uncashed with something in writing, or take it and serve a whole new notice for the exact balance that same day. Letting it sit is the expensive one. Yes, commercial landlords get a legal path to accept partial rent and keep their notice. Residential landlords, sorry, we don't. And the worst version is taking money that reads as rent for a future period, because that argues your tenancy is still alive. So everything on that notice has to be exact. The second the money moves, the number changes, and you've got one decision to make on that day. Make it that day. So before you go, here's what most California landlords miss about partial payments. The cost is almost never the money. It's the weeks you lose starting over. And most owners have honestly never added up what their own time and vacancy are costing them. And that's exactly why I built the free self-managing cost calculator. It takes about 2 minutes to fill it out, and you can find it at wellspringpm.com/calculator. Also, the links below. If you're already a Wellspring property management client, guess what? We've got this all taken care of for you, and you don't have to worry about it. And one real quick housekeeping thing. Everything in this video is completely educational and informational only. It's not legal advice. I am not your attorney. I'm just a property manager. Every property in every situation is a little different. So if you've got questions about yours, talk to your own legal counsel. You can reach us at wellspringpm.com or call the office 760-371-4282 extension 101. That line comes straight to me. I'm Chrissy Wade. I'll see you in the next video. Have a great week.